Welcome to Sherlock Exposes. In this edition of the podcast, U.S. Government Exposed, U.S. versus Crater, Bellwether Crypto Case, Supplemental, The Madness of David Cirilli, FBI Special Agent, and Judge Denise J. Casper. Exposing FBI and U.S. District Court doublespeak, intimidation, and collusion. U.S. versus Crater, U.S. District Court, District of Massachusetts, number 19-CR-10063. If you missed part 3 or any other parts of our expose, you can find those at Sherlock, that's Sherloc, Sherlock.substack.com. You can also support our work at the site. The too long didn't read version. Bullet 1. Why does this matter and why should I care? 1. Doublespeak is extremely powerful for weaponized government agencies. They are able to lie, suppress, and intimidate, with the full power of media fueling their narrative. 2. FBI Special Agent David Cirilli, under oath in grand jury testimony, affirmed that MyBitcoin was a cryptocurrency. The government tried to get him to answer differently, and he didn't. Cirilli also affirmed that MyBitcoin founder and CEO John Roche controlled the MyBitcoin social media accounts and email address. 3. New whistleblower evidence shows that Roche directed and controlled the development of the MyBitcoin website, the MyBitcoin exchange website, and the MyBitcoin Pay website. 4. Judge Denise J. Casper, U.S. District Court in Massachusetts, infringed on Randall Crater's constitutional right to present a defense, violating his Sixth Amendment rights. Bullet 2. What should I do next? 1. Read this expose and review the documents linked to it. Also, listen to this podcast again to make sure you catch all of the information. 2. Share it with as many people as possible, share it on social media, and share it with news outlets. 3. Please support our work at Sherlock.substack.com. There you will find our Give, Send, Go campaign to continue to uncover government corruption. Editor's note: as we receive relevant information, we will publish supplemental pieces as a part of this expose. Part 4 of this expose will be published, but as relevant information becomes available, we will publish it as quickly as possible. Doublespeak is powerful. Edward S. Herman, in his book Beyond Hypocrisy, describes the principal characteristics of doublespeak. What is really important in the world of doublespeak is the ability to lie, whether knowingly or unconsciously, and to get away with it, and the ability to use lies and choose and shape facts selectively, blocking out those that don't fit an agenda or program. Throughout our expose series on the U.S. versus Crater case, we've shown the lengths that government agencies, the FBI, DOJ, SEC, and the CFTC, will go in an effort to win at any cost, including witness intimidation, suppression of information, lies by omission, and simply making things up. It's all fair game. In this special supplemental edition, we'll get to know FBI Special Agent David Cirilli and Judge Denise J. Casper better, and why what they've said and done proves how deep the rabbit hole goes. Meet the Players, Part 2. John Roche, owner and CEO of MyBitcoin, refused a subpoena because his girlfriend destroyed his computer records. As CEO, designed and controlled MyBitcoin, the website, YouTube, Twitter, and all social media. Received cover from CFTC attorney Jason Mahoney. Was he given a free pass from prosecution? Jason Mahoney, CFTC attorney, involved in multiple parts of the Crater case, both civil and criminal. Provided an affidavit for John Roche, waiving his attorney-client privilege. Has not answered for why Roche would need to sign document as owner of MyBitcoin if he wasn't the owner. David Cirilli, FBI Special Agent, worked with Postal Inspector Jan Koska on Roche's testimony. Confirmed under oath to grand jury that MyBitcoin was a cryptocurrency and that Roche controlled the social media for MyBitcoin. Randall Crater, founder of Grayshore Technologies, licensed technology and provided technical assistance to MyBitcoin, and minority shareholder in MyBitcoin. The Honorable Judge Denise J. Casper, blocked and tackled for federal prosecutors, disallowing defense evidence. Violated Randall Crater's Sixth Amendment rights. The CFTC, SEC, and FINRA Regulatory agencies used allegations against Crater to secure funding from Congress, rushed to judgment over MyBitcoin, creating allegations of fraud against Crater alone that were not fully investigated, and competing for regulatory control of the cryptocurrency industry. Robert Dittmer developed the MyBitcoin website at John Roche's direction, developed the MyBitcoin exchange website at John Roche's direction, developed the MyBitcoin website at John Roche's direction. Email strings show direct communication between Dittmer and Roche about the completed website after multiple inquiries from Roche. We last encountered Mr. Sorelli in part 2 of our expose, where he was part of the dynamic duo with Postal Inspector Jan Koska, who were responsible for the information provided in John Roche's 2020 flip-flop interview, where he stated the following. Roche did not recall how the price of the coin, MyBitcoin, was determined, but believed it was based on supply and demand. Said that Crater was in control of quote-unquote all that. When asked to expound, Roche said that Crater created the MBC software and was in control of pricing, but was unsure of the details. He continued, saying that he had no formal agreements with Crater or anyone else, and he never personally sold or tried to sell MyBitcoin stock. The informal agreement regarding MyBitcoin was to split the company 50-50 with Crater. Roche's understanding was that Crater was financing the company through his North Carolina slot machine business. This seems to be convenient memory loss for Roche, as he forgot his 2015 statements to FINRA, where he said the following. Roche informed the staff in his interview that he had purchased MyBitcoin software from Crater, who had created and developed it. Although Roche stated and reiterated to the staff that Crater is not associated with the company and has no input. In his telephone interview, he acknowledged again that he owned and operated all of MyBitcoinPay's websites and domains, including mybitcoin.com, mbcpays.com, and mybitcoinexchange.com, and claimed further that, quote, everything is under my name, unquote. New information obtained by Sherlock shows testimony given by Mr. Sorelli to a grand jury where he, A, conveniently does not answer questions, B, is given cover by the counsel questioning him, and C, provides additional evidence that John Roche was in control of MyBitcoin. An interview with the grand jury. On February 26, 2019, David Sorelli appeared in front of a federal grand jury in Boston, Massachusetts to answer questions in the Crater case. The full document is linked at sherlock.substack.com. Crypto or no? As we shared in part 2 of the expose, the government and the courts have struggled with whether or not MyBitcoin Pay was a cryptocurrency. This is very important. In part 2 from the DOJ website, we talked about the fact whether or not MyBitcoin was a cryptocurrency. The DOJ said the following. A purported cryptocurrency and virtual payment services company headquartered in Las Vegas, Nevada, and offer virtual payment services through a fraudulent cryptocurrency, MyBitcoins, which he, Crater, marketed to investors between 2014 and 2017 using misrepresentations about the nature and value of coins. So the DOJ and the CFTC make the statement that MyBitcoins were a fraudulent digital currency, yet Senior Judge Raya W. Zobel for the U.S. District Court for the District of Massachusetts ruled that MyBitcoin was a commodity in 2018, opening the door for the CFTC. At sherlock.substack.com, we go into the definition of what a commodity is in more detail. The question remains, which one is it, fraudulent or a commodity? During Sorelli's testimony to the grand jury, if you visit sherlock.substack.com, look at page 8, lines 10 to 23, and page 9, lines 1 to 19, he states that, quote, effectively, these individuals were selling cryptocurrency that was backed by gold. This was referred to as MyBitcoin. These were coins offered by the company to investors, unquote. Hard stop. David Sorelli, under oath, has declared that MyBitcoin is a cryptocurrency. It's impossible for something to be fraudulent and real at the same time, until Sorelli made this statement. It gets worse. In the exchange following Sorelli's statement, trial attorney Caitlin Cottingham, sensing trouble with the statement of fact made by Sorelli, effectively tries to guide the line of questioning about the status of the cryptocurrency, stating that it was allegedly being sold. From line 19, question, you said, allegedly, they were selling this cryptocurrency that was backed by gold. In the course of your investigation, did you learn whether these coins were in fact backed by gold? Unfortunately for Cottingham, Sorelli didn't get the message. Answer, we learned that they were not backed by gold. Sorelli goes on to give another description, but he never makes the statement that my big coin was not a real cryptocurrency. Instead, he continues through this testimony, providing his definition of what a cryptocurrency and virtual currency are. In contrast to the statement affirmed by Sorelli that, quote, misrepresentations were made to investors and potential investors in my big coin, unquote, Sherlock has shown evidence that, 1. Crater was misled that the gold in this case, presented by Jean Roche and Billy Donahue, was real and spent over $100,000 in legal fees around the issue, and 2. That there was indeed a market for my big coin, and that people were not only actively transacting, but that there were ATM machines that allowed for transactions of my big coin. We also found evidence online today at cryptoground.com that my big coin was listed as a cryptocurrency. Sadly, the evidence that we've shared here was submitted by Crater's defense team, and it was suppressed. If you're asking the question why, that's the right question. Who's in charge of that social media? And what about those websites? Another recurring theme in the prosecution's case against Crater was that he controlled the social media accounts for My Big Coin. While we've shown that Roche himself stated to FINRA that he controlled everything, Sorelli also believes that to be the case. From Ms. Cottingham, question, Agent Sorelli, you testified earlier about reviewing social media accounts. Did those include Twitter? Answer, yes. Question, and the @MyBigCoin Twitter handle, is that associated with the email address mybigcoin@gmail.com? Answer, it is. Question, and was John Roche the person who primarily used that email address? Answer, it appeared to be. So we have Sorelli making the statement that the MyBigCoin Twitter handle and the MyBigCoin email address appeared to be primarily used by Roche. In additional documents linked to Sherlock by a whistleblower, we have an email string that shows John Roche working with a web developer on the MyBigCoin site, the MyBigCoin exchange site, and the MyBigCoin pay site, and links to the working product. You can see the full email string at sherlock.substack.com. The Curious Court of the Honorable Denise J. Casper. The U.S. government chose Massachusetts as the venue for the Crater case, as it has historically worked in their favor. The case landed in the courtroom of Judge Denise J. Casper. As you'll see, after Sherlock dug into the transcripts of the case, we found bizarre things during day 3 of the trial. 1. The TUI issue. Simply put, the TUI issue, quote, holds that a federal employee may not be compelled to testify contrary to his federal employer's instructions under valid agency regulations. Yes, you heard that correctly. Regardless of whether or not a federal employee's testimony could determine the outcome of the future of a person, they cannot be compelled to testify if the government agency says no. This will make sense in a moment. During day 3 of the trial, Crater defense attorney Scott Lopez presents an issue to the court related to a key witness, CFTC attorney Jason Mahoney. Christopher J. Markham is the attorney for the government in this case. From the transcript, Mr. Lopez, we're having some issues with his unwillingness to honor a subpoena. I may be in a position to ask you to enforce the subpoena tomorrow. The court, so counsel, obviously, perhaps at the end of tomorrow, I'll check in with the government about where they are in their case, just so we are sort of technically prepared for the presentation. But, counsel, Mr. Markham, yes, Your Honor, I just wanted to note for the record that the second witness we haven't been able to talk to, he has an attorney, the court. His lack of interest flows both ways. Mr. Markham, yes, Your Honor, so I don't know whether he's actually unable to come or whether he'd be willing to testify or anything. Hard stop. It appears that Mr. Markham's response is lackluster, while Mr. Lopez is doing what you would expect an attorney to do, get a key witness to court to provide sworn testimony. Please note again at this point that government agencies put rules in place that keep employees of those agencies from testifying. Let that sink in for a moment. Lopez, after being delayed by Judge Casper to discuss whether or not the TUI issue applies in criminal cases and violating Crater's Sixth Amendment rights, along with Markham making statements around the relevance of key witness testimony, lays out why CFTC attorney Jason Mahoney answering questions is key to the defense. The court, Mr. Lopez, let me turn to you. And I guess part of my concern is, as I read these regs, I don't think the individual employees are permitted by the regs to appear, but for this notification. So how do you recommend, given what I've said, how do you recommend we proceed? Mr. Lopez. So that's exactly my point. I'm saying that applying the TUI regulations in a criminal case infringes on Mr. Crater's constitutional right to present a defense. Specifically, with respect to the CFTC attorney, Jason Mahoney, he actually asked and was part of the team that was investigating Mr. Crater and was one of the attorneys who actually questioned Mr. Lynch in Mr. Lynch's interview under oath. Mr. Mahoney actually had communications with Mr. Roche and asked for the same documents he asked from everyone, and Mr. Roche refused to comply with that subpoena. At that point, Mr. Mahoney drafted an affidavit for Mr. Roche based on a conversation which basically said, I, John Roche, say my girlfriend got into my office and destroyed all the records and erased my computer, and therefore I can't comply with the subpoena. I want to ask Mr. Mahoney if he did anything to verify that, because as far as it's relevant, there's a third-party culprit argument that I could make with respect to Mr. Roche. In addition, when it came time for the privilege of my Bitcoin to be waived, Attorney Mahoney required Mr. Roche to sign that privilege waiver because he knew he was in control of the corporation. That's relevant evidence that this jury should know because the government's claim that Mr. Crater was the principal operator of my Bitcoin, which just isn't the truth. Hard stop. For clarity, Jason Mahoney, the attorney for the CFTC, A, is involved in key parts of this case and would be a key witness for the defense. B, appears to be able to ignore a subpoena. C, after John Roche refuses to comply with his subpoena because, according to Roche, his girlfriend destroyed his records, Mahoney then drafts and has Roche sign a document that was an attorney-client privilege waiver, not Crater, Roche, as controller and owner of my Bitcoin. This poses two interesting questions. One, if Roche wasn't involved with my Bitcoin and had not talked with Crater in a long time, why did he have to sign a waiver? Two, how was the prosecution able to put this into evidence when they knew better? After this exchange, Lopez is cut off again, and Markham makes the statement that I would like to put on the record at some point why all of this is irrelevant and inadmissible. Interesting response, as the evidence appears to be very relevant. Lopez points this out. From the court, and I'll just say for the record, my memory is the standard for third-party culprit defense is much higher than sort of a completeness of the investigation line of argument. So I want to think about that as well for purposes of relevance. Mr. Lopez. And when thinking about that, think about all the social media that's now going to be admitted against my client. The sum of the parts. What appears to be information that is critical to the case and Crater's freedom was sidelined, quote unquote, until later, which became never. As we've pointed out throughout this expose thus far, the mismanagement of this entire process is a harbinger, and the stakes are incredibly high. Government agencies are working to effectively legislate their way into power. This should scare you to death. We have to be vigilant. If the CFTC gets away with this, not only is the crypto industry severely damaged, and the CFTC then gets to pick winners and losers, but you may find yourself running an illegal money service business for the simple act of writing a check to someone. If the CFTC, DOJ, FBI, and the court system are allowed to continue to suppress the truth, intimidate witnesses, financially drain defendants, and secure funding based on lies, and then use the media as a lapdog to push their agenda, justice in the United States is dead. Editor's note. As we receive relevant information, we will publish supplemental pieces as a part of this expose. Part 4 of this expose will be published, but as relevant information becomes available, we will publish it as quickly as possible. Do you have a case that's in need of research or an expose? Email us, AskSherlock, that's SHERLOC, AskSherlock@protonmail.com. All inquiries remain confidential. Thank you for listening to this edition of Sherlock Exposes, the U.S. versus Randall Crater case.